I am Seepan Parseghian. I'm the 2020-2021 chair of the Houston Bar Association International Law Section. And today we are going to be exploring the very timely topic of the impact of COVID-19 on the immigration courts as well as businesses and their immigration issues. And to help us explore this issue, we have two incredible speakers for you today. And I'll be briefly introducing them and then handing it off to our moderator for the day, Gordon Quan, to facilitate the discussion with Judge Ashley Tabaddor. And so first, Mr. Quan, he is for lack of a better term, a immigration lawyer legend, especially in these parts in Houston. He's a nationally recognized immigration lawyer, and he's the managing partner of the Quan Law Group, and has been practicing immigration law for over 30 years. He has many national, statewide, and Houston local accolades to his name, and I'll spare everyone the list, but to be sure, he's got a ton of them. And he's a certified member of he's certified by the Texas Board of Legal Specialization in Immigration and Nationality Law. And he has practiced and argued before the Executive Office for Immigration Review, the Board of Immigration Appeals, the Board of Labor Certification Appeals, and in federal courts. Mr. Quan also is active outside of his practice of law in the community. He served as the mayor pro tem for the city of Houston, was elected the first Asian American to serve as an at-large member of the Houston City Council back in, I believe, in 1999. And he has also served as the president of the Asian Pacific American Municipal Officials of the National League of Cities. They need a better acronym, Gordon, for that one. And so today, Mr. Quan is going to be moderating the discussion with Judge Ashley Tabaddor, who is joining us from Los Angeles. Judge Tabaddor is, to be clear, appearing here today in her capacity as the current president of the National Association of Immigration Judges. And she was appointed to the bench as an immigration judge in November of 2005. She's presided over the detained, non-detained, juvenile, and mental competency dockets in her court. And prior to her appointment, she served as an assistant U.S. attorney for the Central District of California in Los Angeles. She also served as a trial attorney with the Justice Department Civil Division in Washington, D.C., and clerked for the Immigration Court and Chief Immigration Judge. I'll do the shout out to UCLA, and she's an alumni for UCLA School of Law. And she's also the recipient of numerous awards, including from the Mexican American Bar Association, Armenian American Bar Association, and Iranian American Bar Association. So with that, Gordon, I'll hand it over to you. And right before I do that, actually, if folks who have joined us today have questions for our panelists, they have kindly agreed to answer those questions. If you can please use the chat feature on Zoom to just input your questions, and I will collect those and facilitate the Q&A at the end of the session. Go ahead, Gordon.
Well, great, Seepan, and thank you, Judge Tabaddor, for taking time to be with us this evening. I know we're all excited to talk about what's going on in the courts, especially in these trying times with COVID-19. We never know when we're ever going to go back to court and how we even file things. So thanks also to all, just seeing some of the names of the people who have tuned in, a bunch of friends here in Houston, and I know you have a lot of questions. So as Seepan said, please feel free to put it in the chat room, and we'll be glad to get to those later. Okay, well, you know, not everybody who practices immigration law goes before the court. And so I thought if we could spend a few minutes and just tell, how does the court fit into the immigration system?
Sure. So good evening, everyone. First of all, thank you, Seepan, for the invitation to join you all. I really enjoy connecting with people across the country. And Seepan, for those of you who didn't know, is a good friend. I got to meet him in Los Angeles when he was a member of Pacific Council on International Policy. So he's got an amazing background and just a great human being. So a pleasure to connect again, Seepan, and thank you for the invitation.
Likewise, thank you.
And Mr. Quan, I'm very excited for us to have this conversation. You come so highly recommended, and just even hearing the short bio, I'm already impressed beyond words. So let's dive in. As Seepan mentioned, I am here in my capacity as the president of NAIJ, so please don't quote me as the judge who spoke on behalf of DOJ. That's not what it is. I'm speaking on behalf of the judges, immigration judges across the country who are considered our bargaining unit members. And yes, just to sort of lay the foundation, I think a lot of people, even those who frankly practice immigration or practice even before the immigration court, oftentimes are not fully appreciative of the structural issues that have plagued the court from its inception. So let's start with that. We are a court system that is not in the judicial branch of the government. For all of us who went through the civics courses, you know, we have the separation of powers and the executive branch, legislative branch, and the judicial branch. And I have to say, even myself, I didn't really fully consider the fact or the significance of having a court system that is controlled by the executive branch. So we are a court system in the executive branch. We're not in the judicial system. We're in the Justice Department. All the judges are hired and fired by the U.S. Attorney General. So as we often say, it's a law enforcement agency, and the chief prosecutor is the one who's overseeing the court. We have about 500 judges now. In the last 3 years, we have grown from about 280 judges to well over 500 judges. So it's been an almost a twofold increase in the number of judges. But so has our backlog. Our backlog has gone from about 600,000 pending cases to well over 1.2 million pending cases. And we have about 69 courts across the country. We are, immigration law being a federal law, so it is nationwide, and we have national jurisdiction, and the courts are distributed unevenly, but more representative of the needs of the sort of the influx or the immigrant community. So you'll see a greater number of cases or courts in the West Coast, East Coast, or some of the more sort of border areas. And so this has been, frankly, the biggest issue that has plagued us, is that by being a court system in a law enforcement agency that is accountable to law enforcement priorities, the way that the court has been administered and the way that the court has been utilized has oftentimes been consistent with law enforcement priorities. So I can certainly go into depth about that, but this is just to kind of give you a little framework of the structural issues, the number of cases, the number of judges, and the number of courts.
Thank you. And I know that I've seen that you've been an advocate for changing the system to make immigration judges Article I judges, and that actually has been an issue in this campaign, that some people running for president said the immigration judges should be separate and not subject to this law enforcement background. So how is that coming along? Again, I know you're intimately involved in that.
Sure. So again, I would have to say, even when I was a litigator, at the U.S. Attorney's Office or at the Justice Department, I just took for granted what it meant when you said a court, a judge. So there was these assumptions about independence, an independent court, and independent decision-making authority. You just kind of assume that if there is a court in the United States, or if there's a judge, that those sort of concepts would mean something much more deeply than they do, frankly, with the immigration court. And it was only through my experience with the immigration court that I realized that those concepts really don't have much significance if you don't have the support system in them. So we have a court that has been utilized, the way that our dockets are constantly shuffled, the way that the judges are now subject to quotas and deadlines, the way that they're subject to micromanagement, the way that the narrative that the court is, posting consistent with law enforcement agencies, the constant, or even its reaction, frankly, to the pandemic, has all sort of highlighted the need to have those fundamental support mechanisms that make a court and a judge a judge. So we have been pushing for this for a number of years, but we have seen the greatest amount of support in the last few years, because those areas in which the conflict of interest exists has now been exploited in degrees that we have never seen before. What this means is that to cure this design defect, you need to have a legislatively created court. It needs to be, it's what we call shorthand Article 1. Article 1 of the Constitution, which is within the purview of the legislative branch. And we've had the most amount of support we've ever had in our history for this type of creation. So the American Bar Association has come out with a 200-page report endorsing it. The Federal Bar Association has drafted legislation, proposed legislation. American Immigration Lawyers Association, the largest sort of bar association of immigration attorneys, of well over 10 or 12,000 attorneys. This is just sort of top of the top. And that's where we're at. We've had a number of hearings. I testified before the Senate and before the House Judiciary Committees on this very issue. And this conversation has been really sort of heating up on the Hill. What we just need is sort of somebody to take us past that finish line, so to speak.
Well, great. And we definitely support the concept, and we'll do whatever we can. I know as practitioners before the court, we feel it's very important to have an independent judge who can make a decision in these cases. So let's go to the reality now with COVID-19. You've seen, of course, and we've seen that a number of the ICE detention facilities have had detainees who have been afflicted with the virus. Have you seen more actions toward releasing people on bond or in custody using monitors or other ways to retain jurisdiction over these individuals but not have them in detention?
Sure. So we've, and I can just start with our own experience with the agency in response to the pandemic. It really took us having to create an unprecedented coalition of the trial attorneys, so the prosecutors union, private practitioners, our union, and public health experts to come together and make a public push for the agency to recognize that there's a pandemic. This is what we had to do in March, because in spite of every effort to try to get the administration to recognize that, they were very slow in recognizing it. And even then, it seemed to be just lip service more than sort of a recognition of the steps that needed to be taken. So this is sort of the backdrop of the constant push and the challenge of trying to get the agency and the administration to take a leadership role in that. It took then the shutdown of all the non-detained dockets, but then the continued hearings for the detained docket. However, we would then see that there was this lack of transparency as to what protocols the detention facilities were using in minimizing the exposure to COVID. And the reports were very mixed. And it was not unusual to hear that people were being brought in regularly. They were not tested, they were being cohorted, and then there would be a breakout. And the breakout was something that we would find out at the last minute. There was a lot of concern because we have a lot of co-located courts with detention facilities. So we've had to do a massive push to just elevate this issue, both in the public discourse and on the Hill, and based on that, get the agency to be responsive. Now, having said that, we don't have control over who the Department of Homeland Security, which is the prosecutorial sort of the technical prosecutorial arm, who they decide to arrest, and their initial decision on detention. So we did see that it took a long time before they started recognizing that this sort of maximum capacity detention was just not going to work with the COVID protocols. At this point, there's been extensive amount of litigation across the country that has been brought on behalf of the detainees dealing with these lack of transparency and adequate protocols in the detention facilities. What we have seen on our part is that the number of cases has drastically dropped. So right now, the detention facilities, based on reports I'm getting from judges across the country, are at the lowest sort of capacity that we've seen in recent history. And because of the sort of the push and I suppose some of the litigation and the recognition that the protocols are in many ways incompatible with the model of detaining immigration population, that those detention capacities are right now the lowest that they have been.
Well, I'm happy to hear that they're finally paying attention to it, because it was a terrible situation for everybody. Now, I know also that the service, well, I don't know, this EOIR has taken to these video teleconference centers so the judges don't have to be physically present at some of these hearings. Do you see this as a trend, and how is that working out?
So yeah, so that requires a little bit of sort of step back in history for the agency. The agency has been very committed to video teleconferencing as a means of conducting hearings. In fact, the Fort Worth Adjudication Center was opened a couple of years ago. This is, from my understanding, that the agency has a deep commitment to expanding video teleconferencing. And since then, practically all of the courts across the country have been equipped with video teleconferencing equipment. So this is a little bit of a double-edged sword. So on the one hand, it is obviously it provides ability for people to connect from different locations. So it does help with efficiency in certain ways. It does help bring people together in ways that are that wouldn't otherwise work out in the past. And we've seen them wanting to utilize it in a more expansive way. Before the pandemic, the challenge of the video teleconferencing was that the agency was taking a very sort of assembly line justice approach. So what they were looking to and were doing is extreme micromanagement of the judge's docket, and using video teleconferencing as a mechanism to basically split up hearings into component parts and just have different judges come in at different points from different places. So this was creating, from our perspective, a lot of challenge in terms of continuity on a case, or the judge's ability to get up to speed and be able to sort of control their dockets and have some sort of essentially sort of a long-term traditional role over their docket. However, during the pandemic, it certainly has provided a short-term solution where individuals who are in detention facilities are able to continue to have their hearings through video teleconferencing equipment. So let me emphasize again, video teleconferencing equipment is not the same thing as remote video hearings. And that is a key distinction, because for video teleconferencing hearings, all the parties need to be present at a government facility. So you either have to be at one of the court facilities that has the video teleconferencing equipment, or you have to be at a detention facility where DHS provides that video teleconferencing equipment. So that has helped to a certain degree with the detained hearings. But a lot of times what we also found is that the represented individuals, the attorneys, were having a hard time connecting with their clients, because the clients were now in quarantine or in facilities that will not allow access to counsel. And so it was just a little bit of a patchwork of trying to connect people, not in the most ideal situation. And that's what I'm hearing right now is the hearings are continuing to go forward. The attorneys are appearing by telephone. So we have the telephone conferencing for the attorneys. The respondents, which are the immigrants in detention facilities, are appearing by video teleconference and are seen by the judge. So it's only the judge and the clients who are seeing each other. The attorneys are only hearing each other. So it's at best a band-aid solution to try to go through this sort of exigent circumstances until we come up with a much more feasible and a long-term better solution.
Right. I can just imagine trying to represent somebody without seeing them or the judge. I know I've had a few hearings with the Fort Worth Center, and the judges are sincere. I mean, they're trying to do a good job, but lack of personal interaction really makes a difference when you're looking at credibility issues in many of these cases. So,
I agree. I mean, we definitely believe that an in-person hearing of everyone in the same location is sort of the ideal, but ideal is not necessarily the requirement for hearings, as you all know, that there is a distinction between sort of ideal versus sort of the fundamental fairness or due process, and the judges do the best they can to make sure that everybody has an opportunity to present their case. But there are a lot of technological and logistical challenges. We hear problems with dropped calls, the pixelation of the video teleconferencing, or like you said, difficulty really sort of being able to real-time connect with your client. So it's really requiring everybody to try to get creative, and it slows everything down considerably. Many people may not recognize it, but over 90% of the individuals who come before the court require interpreters. So when you are in person, the interpretation can happen simultaneously, which means as you and I are speaking, the interpreter is translating for the person. They have a headset and things can go relatively smoothly. If everything is done telephonically, everybody has to wait. Every sentence you say, you wait because it has to be consecutively. And it just becomes, to a certain degree, quite challenging and time consuming.
No, I agree. And we're all adapting to new technologies at this point, but it doesn't seem like it's perfect for our needs here. Now, on this issue too of new technology, you know, just filing things with the court has sometimes been a problem. Going down there, of course, we have to have gloves, we wear masks, and anything to file at certain times. Some areas are trying this electronic court administration service. I don't know if you're familiar with the ECAS system.
ECAS,
and so how have you seen that evolving?
So I think it's probably, you know, again, good time to pause a little bit just to make sure we know what we're talking about. The video teleconferencing is simply the connection by video of individuals within government sort of facilities. That's just the ability to real-time connect with each other and also have those connections, the verbal part, the oral part, be digitally recorded, because as you know, these proceedings have to be recorded. And the software that they have, the agency has it limited to the technology that's in the courtroom. From the first day of the pandemic, we have been pushing to get the agency to get to a video remote hearing so that we are able to connect, let's say, through the same way that we're doing, through this Zoom, which is everybody laptop in their own safe telework locations. The agency has been absolutely so far dragging its feet, and only through recent litigation, through the Newark court, the Newark, New Jersey District Court, did they actually have to start providing some sort of video hearing connection. The other part of the equation is the ECAS that you're talking about, because now I may be able to speak to you, hear you, and even record you as we're having this hearing, but I don't have the file, right? So if I'm not at the court or you haven't had an opportunity to submit it, I don't have it. Right now, almost everything we do is by hard copy. We are decades behind other courts. And that's what the ECAS system is. For the past 20 years, Congress has been consistently funding the agency and mandating it to get us into that 21st century world of having both electronic filing, electronic records, electronic tools for the judge to be able to interact with those databases. And we have a number of courts that have sort of been experimenting or piloting those, but we are far from getting to an electronic record or electronic filing. What the agency has done in the pandemic, and that was again because of extreme push of NAIJ and a lot of other stakeholders, was to allow for email filing. So what the agency did is to say, okay, you know, we don't have this ECAS up and running, so we'll set up an email account and people can go ahead and email their filing. So what happens on our end is that the clerk has to then print it out. So that ends up being a huge sort of drain on resources and staff time to create essentially what are supposed to be electronic files, turn them into hard copy, and then sort of distributed. And a lot of the judges who may be on telework, now it needs to be boxed up and FedEx and go back. So it really is a logistical nightmare in many instances and quite chaotic.
Well, it seems, I don't know, interesting that it's been so difficult, but the federal courts have been doing this for years. And you would think that if the federal courts can do it for major cases, the immigration court could just adapt a similar system. But I don't know what the.
But I can tell you why. It keeps
What?
going back to what I say. It is that fundamental design flaw, because it's not just enough to give judges independent decision-making authority, which we have supposedly on paper, but we're being hired and fired by the federal prosecutor. There's the other component of a court. It's the administration of the court, right? So, you know, the whole infrastructure, all the professionals who have been trained and are experts in doing exactly what you just said, which is to make the support apparatus for these hearings work smoothly. But when you have people in power, people who've been appointed not for the purpose or not with the qualifications or experience in that field, but for the purpose of keeping us in line with law enforcement agency policies, that's where the problem is. The policies and the priorities are not about court priorities. It's about what the administrative de jure's priority is on messaging and policies.
Okay, well, recently the immigration judges have been given the right to pre-terminate asylum applications, and a large percentage of the cases before the immigration court deal with asylum. So this is a new ball game for us because you file the case and you wait for the hearings, but the fact that the court can just say, hey, we're not having a hearing, we decided the case it doesn't meet a certain standard. What do you think we can do, or do you have any idea how we can take a kind of an affirmative action or proactive action to kind of avoid pre-terminating a case?
So I think what I could say on that is we have definitely seen a large influx of sort of asylum seekers, and the vast majority of the cases that we are adjudicating have to do with asylum. The other thing I can say is that a big chunk of those are coming largely at this point from sort of Central America and Mexico, sort of south of the border. And most of those cases raise claims that fall within that particular social group, sort of that catch-all category of asylum. For those of you who may not know, asylum is a mechanism by which people can seek to remain in the United States based on a fear of being persecuted or severely sort of harmed. But the harm has to fit into this 5 pre-designated boxes. 4 of them are pretty self-explanatory: political opinion, race, nationality, and religion. But the 5th one, particular social group, has had a very long and controversial history, which has been very connected to, again, this problem of having a court and a law enforcement agency, because administration after administration has attempted to redefine particular social group and has tried to either utilize it to advance certain policies or utilize it to limit certain other things. So I think what we've seen now in the last few years is that there's been a big focus in narrowing particular social group, and essentially minimizing the ability of utilizing particular social group as a basis for asylum. So the Attorney General has used the certification process, which is another way of saying that the prosecutor has stepped in, used the case to rewrite the law, and that's the certification process that we have to live with, to rewrite the law and encourage judges to utilize a very aggressive mechanism to cut asylum claims at the outset. And obviously the most readily apparent way to cut asylum at the outset is to focus on that particular social group theory. And I think it is going to be it is very critical for people to be on the applications and filings to identify the particular social groups. And to identify the particular social groups, to include evidence that would support the elements of it, so particularity, immutability, social distinction, so that it's clear that there's evidence in the record that would support the proposed groups, and frankly make sure that the testimonial evidence, the declarations and all of that, indicate that these are essentially, factual findings that need to be developed or are being presented, so that either it would help you, frankly, if you do it, and the government sees the Department of Homeland Security reviews it and says, actually it looks like it fits in, and I think we can talk about sort of ways that you can perhaps get some agreement from the government. Or on the other side, if it really is a disputed fact, that it's quite clear at the beginning that these are factual determinations, that this ultimate legal decision relies on factual determinations that need to be developed further, or at least have an opportunity for a hearing.
Good, thank you for that information. You alluded to the fact that the caseload has really exploded, twice what it had been previously. As you indicate, there's over 500 judges now. I estimated each judge, if you averaged it out, would have over 2,400 cases to work over. It's taking on the average over 770 days before a client's case will be heard. Some people, of course, are happy to wait. Other people are like, God, I have an easy case. Can't we move it up on the docket? I mean, we just need 5 minutes, 10 minutes, Your Honor. So, has there been discussion on ways to kind of run a more efficient docket? I mean, I have people who have, say, a consular interview ready for them, and I just need voluntary departure. I just want voluntary departure. I have people who have an approved relative petition. It's a clean case, nothing wrong with it. I just need the court's time. What have you seen, or have y'all spoken about methods of efficiency?
Absolutely, and that's something that we're very committed to. And I think in certain ways, so is the agency, because for them, certainly completion is a priority, and certainly a primary priority. So let me also put that in perspective a little bit more. The judges fall into the dockets of the judges fall into two broad categories. One is the individuals who are in detention facility, and others who are in a non-detained facility. About a third of the judges hear cases of individuals in a detained facility. And because of the detention consideration, the dockets of judges who are tasked with those cases have to be limited, because you want to make sure that they have openings and ability to accommodate individuals within a relatively short period of time. I mean, we're still grappling with it sometimes, but within a couple months, 2 months, 3 months. So about a third of the judges who deal with detained dockets have maybe anywhere from 100 to a few hundred cases on their docket. So that automatically takes out from that 500 number, it's about 150. So what are you left with? 2/3 of that to those judges. It's not unusual, and I just found out today, for example, New Orleans has 30,000 cases, pending cases, for 3 judges.
Wow.
So, and when I first started with the court in 2005, we considered 1,500 cases or 2,000 cases to be outrageous, which I still think is absolutely outrageous. More recently, it wasn't uncommon to hear of judges were 4,000 or 5,000 cases, but even today, when I heard about the 10,000 case, it's outrageous. So yes, this is a long way of saying everybody's looking to see what can we do to try to do that kind of efficiency modeling, as you mentioned. So a couple of things that I would recommend, particularly for practitioners, it's just like what you mentioned about cases that are 5-minute cases, or cases that should really be brought to the attention of the court. Depending on the relationship, or depending on the posture of the local Department of Homeland Security office, and I realize it falls all across the spectrum, but depending on that, assuming you're finding a reasonable sort of office to work with, the most helpful way is frankly reaching out to them and getting their agreement. I'm starting to see more of that with the pandemic, because they too don't necessarily want to force something into a hearing. But I do agree that it has to be on what I would call sort of the no-brainer cases. Like you said, that person doesn't have criminal history, they don't have any extensive problems. It is, like you said, a voluntary departure. The person wants to give up everything and just leave. So those are the ones that we are seeing the greatest amount of sort of agreement. The other ones we're seeing agreement on are, let's say, some of the 42B applications, cancellation applications, where the proof, the extensive sort of, you're talking about the hardship on the children. We're seeing that too, that there's definitely been a history where the government has agreed to that. In other cases, if the government is disputing it, so this is now more to kind of explain what happens on our side. If the government is disputing, no matter how much you may believe this is a 5-minute case, if it's a credibility determination and the government is disputing it, or if it's something else that requires a hearing, now the judge is faced with 10,000 other cases who need a hearing, and unless there's something that is really compelling about why this particular hearing, like you're talking about an age out case, or you're talking about a situation where the families, they're in danger, and you're trying to sort of maybe help them come to the United States, and the asylum case is very strong and very well corroborated and all of that stuff, then I think it's helpful to bring it to the attention of the court. I have done for myself what's been quite helpful, and I encourage the parties, is at the master calendar hearing, or even if you're doing master calendar sort of pleadings, written pleadings, to request a pretrial hearing. So requesting a pretrial hearing is essentially saying, I just want 10 minutes of your time, judge, or 15 minutes of your time to just highlight some of the issues, or to just sort of narrow the issues. And this ends up, hopefully, if the judge has the ability to accommodate it, it then is going to trigger the government trial attorney to be assigned to the case. And there's going to be a hearing, so the government trial attorney is going to have to review the case. So then they're much more inclined to actually make a decision on the case. And so depending on who you get and how well or how persuasive your evidence is, you're much more likely to then maybe have the government say, you know what, judge, we don't dispute credibility. We do think this is a particular social group issue. It is a legal issue. So why don't we just take everything, into evidence, and we'll just brief it. And, then you have to be comfortable with knowing that your sort of the affidavits or other witness sort of declarations are sufficient for you to make your argument before the court, knowing, what the case law is. So that's one way that I would say. But we are now looking at, because of the pandemic, trying to go towards a more written-based model. Because before, everything was all about sort of coming to court, having 50, 60, 70 people coming to court at the same time, trying to do these preliminary master calendar hearings. But I think there's definitely a big push now, and an understanding that for represented individuals, so much can be done on paper, especially at the beginning. So that's, I would say that's probably your best bet, is if you want to help the case move along, is frankly, before the very first hearing, you can do your written pleadings, get all the applications done, do the biometrics, pay the fees, have everything ready, even got in touch with the government attorney and see if you can do a pretrial conference, and come to court and say, fait accompli, we've done this, and this is the singular issue. We only need 45 minutes, and judge, if you can accommodate us into this time or frame, we would appreciate it.
Sounds good.
Good luck with that. I know there's a lot of ifs in that. I hear you, believe me. But in trying to sort of show you from our side the constant juggling that we have to do, and I do try to be very mindful. I would say the one thing we haven't talked about is one of the challenges the court has is that not everybody is as reputable as you are, Mr. Quan, or some of your great colleagues, is that we oftentimes see a lot of things that just fall through the cracks because the attorneys have done a less than adequate job. So that then puts the onus on the judge to have to do more hand-holding, or conversely, the respondent ends up paying is being prejudiced by it, and so it just becomes another challenge that derives from the fact that we don't have contempt authority and a whole other sort of control over our dockets that we need.
Gordon, excuse me if I can interject here, but
sure.
I would love to know your perspective. Have you tried the pretrial conference, strategy, and has that worked? And I'd love to know your thoughts on that.
Unfortunately, that's a foreign concept to me, but I like the idea. I generally tried to file motions to advance a case and try to work that way to see if we can persuade the judge to at least move it up on the docket. But I was going to ask the judge, as far as like, do you set aside a day of the week or every other week for these pretrial conferences? Because it seems like if you're so booked, I mean, again, I know times are different now, but when you had master calendars, you have like 50, maybe 100 people coming in, and you just have to go through that docket. And so to ask the judge, Your Honor, can you give me 30 minutes? I mean, they're like, Mr. Quan, is that in like what year we're talking about? I mean, because
it really depends. I hear you, believe me. It just depends on the particular court and particular judges too. So, but we definitely have, like, we did have in Los Angeles and now I'm in Van Nuys, that there is this receptiveness to what we call short matters calendar. So it's one of our supervisory judges herself. Friday afternoons was her short matters calendar. Mm-hmm. So she would put 10 cases that were designed for that very purpose, that you're spending maybe 20 minutes, 15 minutes, 20 minutes, something, you're going to go beyond your traditional master calendars. The other thing I would say is that, again, it depends on your judge and how well you've worked with the DHS and how well you've documented. But a lot of times these pretrial conferences can be accommodated on the merits calendar. So, you can request sort of 15 minutes, 20 minutes before the actual scheduled merits, the trial date of another case that's scheduled for a full trial. Or sometimes those cases get dropped and there's some openings, right? So if the judge is able to then plug in those cases, is to say, okay, I have a whole set of cases that can now benefit from that, and you're ready on a short time frame to come together, it can be done. So I certainly don't want to sort of commit judges to it, but I can say it is something that we support and we have tried to empower judges to do.
Well, I want to get to the questions from the rest of the audience, but a few other questions. I know that many times people think that immigration courts are only about asylum, but you hear a number of other types of cases. And do you hear many cases where people are arguing about visas, as far as business visas, as far as whether they qualify on these? Because I know the international law section has a lot of business people. And I guess what I see sometimes is a person, when they were young, they had a marijuana conviction or something, they forgot about it, then they had a green card, they come in, and next thing you know, they're in detention, and they're like, but I'm a good guy, I'm vice president of this company now, and why are they holding me? I mean,
those are good questions. We definitely do see some of those. I mean, while asylum is the primary form of relief, we do have, I think I alluded to cancellation of removal, which is not visa-based, but we do have adjustment of status adjustment of status is all based on visa applications. And this is one of the complexities of immigration law, which is that it has so many moving parts and different people have jurisdiction over different components of it. So if somebody is in the United States sort of without status or even with status, and then they fall out of status, and now they want to use a visa in order to sort of adjust that status or regularize their position, if they're in court with us, the actual visa has to be adjudicated by USCIS. So that's what we call the benefits arm of Department of Homeland Security. But that in itself is not enough for them to then just get sort of protection or status. They have to now adjust. So then we see that, and those are some of the challenges, because you have to now show you're not otherwise inadmissible, because Congress says it's not enough to just have a visa. The visa is essentially just a permission. Like, it just means now you're in a group of people that we can consider letting you in. The next question is, do you fall within the 10 or 12 or 15 category of people we don't want, such as, let's say, criminal conviction, people with criminal convictions, public charge, contagious diseases, prior misrepresentations, a whole set of grounds of inadmissibility. And so we definitely do see that. We don't have, per se, jurisdiction over the actual visa decision, but we do have jurisdiction over the ultimate application on whether the person should stay and be granted sort of that adjustment of status, or whether whether the visa is insufficient because there are all these other considerations like the conviction you mentioned.
And just to follow up on that,
Sure.
Oftentimes we have visa petitions pending with the service, and it may take a long time. And we're like, Your Honor, I mean, we had an interview on this case 6 months ago. We're still waiting for a decision. How open are you to continuances waiting for that adjudication by the service?
That's definitely something that comes up, and there's been, so this is yet another part of sort of being a court and a law enforcement agency, right? So in certain administrations, they're much more supportive, and so there isn't this massive pressure on judges to move cases along and do it fast. This past few years, there's been extreme pressure on the judges to just push the cases through. And one of the cases that the Attorney General utilized, again, to push the judges was a matter of LADR and focusing on a continuance and basically telling the judges that if you are going to continue the case, you need to partake in this extensive analysis. And there's this multiple factor analysis of pros and the cons and how many times and where does this go. But if you want to deny the continuance, you can just deny the continuance and push the case forward. So of course, the judges are, from our perspective, constantly reminded that due process is the ultimate consideration, that the judges have taken an oath of office, that you really need to remember the fundamental fairness. So I can't really answer the question in terms of particular cases or even with particular types of visas. I would just say that these are the factors at play, and when you are requesting those continuances, you want to really be mindful of the current requirements on the judge, and therefore what you need to provide to the judge in order for the judge to be able to adequately assess your request.
Just a couple more questions and I'll open it up to the audience. I know that I want to make sure that audience members have a chance to ask the judge some questions. The question is, when are the courts going to reopen? Because every 2 weeks we get this notice, non-detained cases have been canceled till November 30th. Then non-detained cases have been canceled till December 5th. And it's like, we're getting our clients ready. We have a hearing date. We say, line up the witnesses, get the documents, because we have to meet a filing deadline. Do you know anything more about when the courts are going to reopen? That's
a very good question. So it's a little bit of a longer answer. I'll try to shorten it because I know Seepan also wanted to highlight some of the questions there. The detained docket has never shut down.
Right.
So that's one thing that has been going on the whole time across the country. It's had a lot of hiccups. There's been a lot of court closures because of people coming down with COVID, detainees coming down with COVID, infecting others, and quarantining and all of that. So that has been ongoing. The non-detained docket was suspended in March for an extended period of time. And about a month and a half ago, the courts, based on a 3-phase process, have been resuming the non-detained docket. So some courts, and we now have well over a dozen courts that have resumed hearings in a very limited capacity. Most of the time they've been in sort of cases that are ready for trial. In some cases in Los Angeles, they are doing master calendar hearings all on telephone sort of conferences or on paper. I believe Texas hasn't reopened. So since you guys are in Houston, and that's probably where you're coming from, so every week they make an announcement of whether a new court has been added to that reopening model. And that's been one of the things we've raised with them, is to say, when you make these announcements, they're so short term, it's just impracticable for people who for months and months and months, all the cases have been canceled, to now be ready. Because when do they know? It's constantly expending so much time and resources. And then even when we resume the hearings, half the cases aren't even being scheduled or can't even go forward. So this actually has been, again, another one of those challenges with the agencies, because they're not approaching this from a court model. They're not approaching this from transparency. They don't engage with stakeholder meetings. They're completely tone deaf to the impact of their decisions on the practitioners. We are trying our best. We held a stakeholder meeting a couple months ago to highlight what we know, And we have really pushed for them to give us as much advance notice as possible. So now I think the notices are maybe 3 weeks. I think, now they're saying, the next, court to be reopened won't happen till November 13th, I think, something like that. So you're getting now more than the 10 days, sometimes 7 days. But that is a challenge. And a lot of the judges are, as much as I know, they're very sensitive, especially once the case reopened, that perhaps you're not ready and you haven't had adequate time to really prepare for the case.
Well, I thank you for pushing that, because it's been a difficult challenge for us. So, Seepan, do you have some questions? I have another question, but I'll defer to the audience.
Yeah, so we do have one question, and I believe Judge Tabaddor probably already touched on this, but might as well put it front and center. So one of our attendees, who's an attorney, is wondering whether his client's asylum case is likely to be pushed, even though she's not in detention and has a February setting.
February 2021 in Texas?
That sounds
I
that
guess,
way.
I assume so.
Yep.
So I wish I had that magic ball as to know exactly what is going to happen. What I can tell you generally is that for the larger courts, with what's called phase 1 reopening, there's been team models. So they have divided the courts, particularly the larger courts, into 2 teams, and they're rotating it. And so for 1 week in, 1 week on telework. So the week that you're on telework, those cases get all pushed out. In addition, the non-detained hearings have been reduced to 1 trials in the morning and 1 trial in the afternoon. So that obviously significantly reduces sort of the number of available slots and the sort of as to what's going to go forward. In terms of February, I honestly have no idea. It really depends on a whole slew of factors. The number 1 factor we know is that this administration's focus has been on having the U.S. attorneys, the local U.S. attorneys, make the decision on when to reopen the courts. And the disconnect is that the U.S. attorneys are making the decisions for their office, but they're not considering the impact of it on the court, because they're not overseeing the court. But then the court utilizes that decision as the determining factor. At this point, I think Texas is going through still a lot of spikes in terms of the numbers. And so we haven't heard anything in terms of reopening. Dallas court, I would tell you, that has been hearing just detained cases, has shut down over 8 times in the last month over COVID-related incidents. And I hate to say it, but one of the challenges is that there seems to be a disconnect about recognizing that if you don't keep social distancing, if you don't wear masks, if you don't minimize the number of people, you are going to get people infected. And when you get people infected, then we have to be proactive, because we can't endanger other people's lives. And so what ends up happening is that if there's loose sort of following of those protocols, then there's the incident reports, once the court reopens, goes through the roof. And when it goes through the roof, they have to close it down, they have to clean it up, they have to quarantine people. So that's also one of the challenges in terms of the practical consequences of reopening, because our old model was stuffing so many people in such a small space. And that old model is completely inconsistent with the new normal. So we have to be looking at video remote hearings, which is what we've been pushing for, a reduced number of people at any one time, more adjudications on the papers, and more collaborative effort between the parties.
And one follow-up question we got from that, Gordon, is do you see, Judge Tabaddor, that there will be some of these adaptations during the time of the pandemic that are here to stay?
I think so. I definitely think that the pandemic has brought a new way of looking at things. The agency was very much before committed to basically pushing as many cases under in-person hearings as much as possible. And I think now there's been a recognition that, well, we don't necessarily always need to come together for all these preliminary issues to be resolved. Particularly for represented counsel, you can have so much of the issues done on paper. If you have good counsel, the pleadings can be done on paper, applications can be prepared, all of things can be filed, And maybe you can have just a telephone conference about, okay, let's come up with a date that everybody can agree to, or is there a preliminary issue that we need to do a motions on? So I think I'm seeing that trend. The second one is that we're really sort of pushing for that video remote hearing so that it would allow for the ability to visually connect with each other, not just through telephone, because the telephone and the technology of that is good for now, but it's not a good long-term model. And in terms of the collaborative effort, I think there is much greater push for pretrial conferences, narrowing issues, and what Mr. Quan mentioned is perhaps adjudications on the paper, sort of on those preliminary matters. So if you have a very strong case, best to try to get the government to agree to it.
And we'll probably make this the last question because we're running out of time here. And so one of our attendees is asking, what can we do to have more coordination and meeting of the minds with the Office of Chief Counsel? The complaint being that they won't even give out their email addresses. So we can't even confirm with them prior to the hearing if they have run our clients' biometrics.
That's unfortunate, because I can tell you in Los Angeles and Van Nuys, it's actually quite, there was a change of leadership there a number of years ago, and they really empowered the attorneys to be attorneys. And so there's a regular communication between the trial attorneys and the private bar. And now with the pandemic, I mean, I was having a conversation, we had a hearing yesterday, and you needed to have submitted documents. The government counsel didn't have the documents. And so right off the bat, here's my phone number, here's my email address, send it to me right now. So there is absolutely no prohibition. There's no national rule against it. The most I would, I guess, suggest is just trying your best to establish greater ties with the local chief counsel's office. Maybe try through the local bar associations to request those meetings. We do have local reps in all the courts, and we also have our communications director, Sam Cole. And I know that we've said that we support stakeholder communication, and so to the extent that we can help, we welcome that.
Okay, and let's get one more question in there before we wrap things up. Sylvia asks whether the pandemic has had an effect on the transfer of cases from the EOIR to the BIA.
I guess I'm not quite sure if I understand that, but if the question is whether files have been able to be sent on appeals for review, I believe in large part they have stayed consistent. The Board of Immigration Appeals staff have all gone on to full telework, but their work actually lends itself greatly to telework. They're all sort of on paper, and there's been a greater emphasis on getting the Board of Immigration Appeals onto that ECAS system that Mr. Quayle referenced. So they're really trying very quickly to try to get the technology to connect sort of online as much as possible. And I continue to get oral decisions, transcribed oral decisions for me to review, and notice of appeal, sort of recognizing that they're going through it. I don't have direct information, but that's been sort of the experience of myself and other colleagues.
Great. Gordon, any last thoughts?
No, it's just been a pleasure to have this conversation, Judge Tabaddor. And I do regret that we can't meet in person and just get to know each other and look at some of these ideas. Do you think we need to contact the U.S. Attorney's Office and say, hey, U.S. Attorney, we need to give us a little more lead time on this thing? Because
absolutely, that's been some of the ways that we've, I know that other bar associations and other private bar members have tried to do, is to just inform the U.S. Attorney's Office. I think they know, but I don't know if, some of them say they do, some of them say they don't. Let the U.S. Attorney's Office know that this is, your decisions impact the immigration court in your locality. And so if you can let us know what you're relying upon, or if you can let us know what, what the thought process is, or let us at least have an input, or give you some, have a connection, we certainly encourage it. And as I said, we've been encouraging stakeholder meetings and stakeholder connections throughout the time of the pandemic and before. That's
a great idea. I'm pretty good friends with the AUSA who handles immigration matters, so let me raise that issue with him.
But before you do that, make sure that the Houston Bar gets together and officially endorses in an Article I independent court. So,
okay.
We're happy to work with you on that
Yes,
too.
I don't think anybody's going to object to that at all. So thanks, Seepan, for organizing this, and I hope those who participated received a lot of good information. I know I did.
Yes, thank you both, Gordon, as well as Judge Tabaddor, for your time today, and thank you for everyone that joined us. I already was getting private messages saying what a great event this was, and they really appreciated the candor and transparency with which Judge Tabaddor provided her insights and experience, and great questions from Gordon as well. So thank you all for your time today, and thank you also to my firm, Beck Redden, for helping sponsor this with the Zoom account. So, and everyone have a good evening and take care.
Thank you, everyone. Thank you, Gordon. Nice meeting you. Thanks.
Good meeting you, Ashley.